Okay. Hi, everyone. Hope that you have been enjoying the summit so far. I'm Ann Lehman from the Criminal Justice Commission. So it's really great to have so many people here at the event. I'm just going to give a real quick introduction to the speakers that we have today. Carol Poole from the National Criminal Justice Association over here on my left, your right, and then Lauren Dedon from the National Governors Association. Just so you know, we are recording this, so maybe try to keep background noise to a minimum if you can. And thank you very much.
Good morning. I am Carol Poole. As she said, I'm with the National Criminal Justice Association. We are a national organization out of Washington, D.C., and we have a membership made up of people from all aspects of the criminal justice system, government, nonprofit, universities, and examining the criminal justice issues, the concerns, the priorities from throughout the country. We have a presence on the Hill to keep our membership informed and to serve as a voice for criminal justice priorities in Congress. This morning we're going to talk about pretrial justice and the National Criminal Justice Reform Project. I'm going to cover the pretrial justice portion and then turn it over to my colleague, Lauren. And she's going to help me with my slides because I was trying to figure out my notes and the microphone and all of that. So if you hear me doing the okay or the flagging, that's what's happening. We're going to, just to kind of tell you where we're going to go this morning, obviously, your state is looking at a whole lot of criminal justice issues. You've had this amazing justice reinvestment process going on, and there is a lot of focus on many aspects of the criminal justice system these days and how we can improve it, make it fairer, more efficient, and reduce population that we incarcerate. One of the issues on which there's a lot of focus these days is pretrial justice. Have a quote for you that I won't read to you, but it came out from the Justice Policy Institute in a report that they recently did. And bottom line, what they're saying is that our current system of bail in most U.S. jurisdictions is incapable of doing the job that we expect it to do. There are many people who are feeling it has become a very dangerous and outdated and unfair process that's very expensive in the criminal justice system. And the focus on the fact that money bail gives a certain advantage to those people who have resources and creates problems and has a lasting impact on those who do not have resources. What we see is that very often poor and low-risk defendants remain in jail, and there is research, a lot of research, that has been done throughout the years, actually, to look at what this is causing in our system. We will start this morning kind of looking at the current national overview and then a little bit of history, where it came from, and then we will also take a look at Oregon's plan to focus in on this issue. Just before I move forward, I would like to get just a sense of who you are and where you come from. Probably most of you from Oregon, I know. But how many people actually work in pretrial services programs? Okay, very familiar with the topic. Law enforcement? Prosecution? Victim services? Okay. What did I miss? Judges, judiciary, excellent. Mental health, okay. Substance abuse, all right. Defense, excellent. It's back there. Okay, we've got everyone. So this is great. This is the best way to have a discussion, is when you have people from all aspects of the criminal justice system who are getting together to talk about this. Okay. We have become very aware in the last few years that of the jail and prison populations. And one of the facts that we know is that unconvicted inmates are driving increases in the jails in the United States. More than 3 in 5 nationally of detained individuals have not had a trial yet. They're being detained prior to trial. The result, as we were saying, is legally innocent people are locked up because they can't afford money bail. And not because, in most cases, evidence suggests that they are a risk of not returning to court or of committing further violence. Colorado has, the state of Colorado developed a tool recently and did, in the past few years, did some research. And what they found out is that 70% of that population being held in jails was either low or medium-low risk, and only 8% were of high risk when it comes to not reappearing at court or in violence or being a risk. So what we're seeing is a population being detained pre-trial that, for the most part, is low risk. Next. To detain mostly low-risk people, of course, is a very costly proposition. And my statistics might be a little confusing just to look at, but I'll explain where they came from and what they're saying. American taxpayers are basically spending $14 billion a year in direct costs, and that includes the cost for keeping people in jail. We look at what we could save by reforming how we do this process, and what we find is that we could save $78 billion if we used evidence-based tools to assess people. And these are actually lost bail costs, premiums that people never get back after having to post bail. This happens frequently if a case is dropped, if they are found not guilty, and so it's costly. But not only do you have the $14 billion in direct costs, they're also calculated an additional $140 billion annually in collateral costs that are related to the jailing of people pre-trial. What we find is that this has a disproportionate effect, of course, not only on low-income people, but it also impacts, it's a racially disparate issue, just as our speaker this morning was talking about how this impacts minorities in our communities. What we see is that, and this comes from the 2010 census briefs, that there's almost a 5 times higher rate of incarceration or jailing of African Americans than for white people, and a 3 times higher rate than Hispanic. And this situation perpetuates the cycle of poverty. Recently, we work very closely with the Pretrial Justice Institute, also out of DC and working nationally. They recently had a 3 days count campaign, focusing in on what happens for that, what might be considered minimal stay of 3 days in jail when people are arrested. And the 3 days came from a statement that was made, unfortunately, in the Ferguson, Missouri incident, when the press was talking to somebody in the courthouse about the people that were being held. And her comment was, well, they were only there for 3 days. So there's been a lot of research done. In fact, the Arnold Foundation did research. Many of you, I'm seeing some heads, so you may be familiar with this, talking about the impact of 3 days. Loss of wages and jobs, housing, family connections, but not only those impacts, but it comes along with a 40% increased possibility of committing future crimes. So it's a very risky situation that we're looking at and the effect. If you look long term, you find that when defendants are kept for the entire pretrial period, they are 4 times more likely to be sent to jail, 3 times more likely to be sent to prison, and they receive 3 times longer jail sentences, 2 times longer prison sentences. It has a massive effect, and obviously 3 days count, and even more makes an enormous difference. Let's look just a little bit briefly at the history of bail and pretrial. We hear of this in ancient Rome, actually. It goes all back, and mostly in the case of bloody battles between feuding lords, but there is a reference to this concept of bail that goes very far back in history. And then, of course, from our 1,000-year-old English roots. But what we have seen through the time, and there is a report that was put out by Tim Schnacky, Mike Jones, and Claire Brooker, that goes in depth, and you probably would find this very interesting if you haven't looked at it. But talking about what has happened through the history, what we see is that there was widespread abuse of the bail system throughout history. We talk about the Statute of Westminster from 1275. And there have been many attempts to address the abusive and unlawful and kind of the irrational practices through the years. And it's been a slow move forward to address the problems associated with the bail system. What is the legal foundation? Of course, in our Constitution, in our U.S. case law, state and federal statutes. Bottom line, it's next. It's based on the principles of pretrial services, which we can see in those parts of the Constitution that you're very familiar with, where they talk about the presumption of innocence, the right to counsel, the right against self-incrimination, due process, equal protection, and a right to bail that is not excessive. There is a very interesting history right here in our old country, where we saw a lot of focus. This is not just a recent thing. We saw a lot of efforts starting in the 20s in Cleveland and Chicago, where they were looking at bail practices. In the 1950s, New York and Philadelphia did studies. One of the most famous is the 1961 Manhattan Bail Project. And it was based on the idea that if the judges did not have enough information, and that if they had more information, that perhaps they could do a more effective job. And what they found is the more information that judges had, the more people that were released. This had a profound effect on the country, an awareness of pretrial justice services, and that was a large marker kind of in moving forward at looking at this practice. There were a lot of extraordinary bail projects throughout the 60s. And then, of course, in 1964, there was a national conference on bail that was sponsored by Attorney General Robert Kennedy. And you probably have seen a very famous quote of his where he says, that there should be something besides the amount of money that you have that determines whether or not you are held until trial. Okay, next. Through the 70s and 80s, we saw a trend of a focus on public safety coming into the whole concept of and practice of bail. There was the Bail Reform Act of 1984, and this required pretrial release on personal recognizance unless that would not assure court appearance or there would be a detriment to public safety. So you see incrementally throughout the years the examination of this practice. And here we are now, moving forward in time. In 2011, there was a national symposium on pretrial justice. Attorney General Eric Holder was very involved in that. And out of the symposium, there was developed the Pretrial Justice Working Group. Many organizations coming together who were focused on this one part of the criminal justice system. And the Pretrial Justice Institute that I mentioned just previously, taking the leadership on that. And we have been very pleased to be part of the pretrial working group, we at National Criminal Justice Association, where many, many national organizations, judges, prosecutors, law enforcement, the national organizations, state courts that are focused on this topic come together and share information. One of the important things anytime that you look at an issue, of course, is making sure that you have defined your terminology. One thing that comes to mind, and I don't know if you have had this in your state, but if you take the term recidivism, I worked in the state of Colorado for many years, and one of the things that we struggled with is that every agency had a different definition of recidivism. You know, is it reoffending, and at what point do you reoffend? And so we realized that we were talking apples and oranges a lot of times when we discussed that one issue because we didn't have the same terminology. The same thing, of course, when you're looking at pretrial justice reform. Throughout the years, we have used the term bail, and it has become synonymous with money. And this causes some confusion. So there is, with those of us who've been working in this issue, I've been a real focus of looking at the difference between bail and money bail. In speaking of bail, the definition is actually the process of release. And then money bail is when that, of course, includes some kind of security or there is money involved. The Supreme Court has said in one of its decisions, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. And so that is the ideal that we talk about coming right from the Supreme Court. So we look at this very long-term part of the criminal justice process, and how do we go about examining it, analyzing it, seeing if changes need to be made. And what we find through research is that there are data-driven alternatives to money bail. There are valid risk assessments, and those of you, certainly in the pretrial programming and in many of the parts of the justice system that you're with, are familiar with these. There are a number of tools that are being used. It's important that they be evidence-based and validated and revalidated, but to make sure that they are measuring what it is you want to measure to assess risk. There's a lot of looking at citations a police-issued order to appear before a judge as opposed to arrest and taking right to jail. Informed release on recognizance, a promise to appear. Another option that people are looking very closely at, of course, is appropriate informed conditional release that include protections for victim safety. There are programs that are pretrial services programs that are, when they do assessment, are not only doing a questionnaire or an assessment, looking at criminal history data, but there's a program in Denver that when there is a domestic violence case, that they also use another risk assessment, the ODERA, which came out of Canada. The Arnold Foundation is in the process right now of validating that risk assessment tool. So Denver has opted. There's a strong victim focus in the state of Colorado that they have victim rights. And so that program, which is one of the SMART pretrial programs funded by the Bureau of Justice Assistance, has decided that in those cases that they will do 2 assessments, one specifically looking at domestic violence issues. There are effective pretrial service agencies that do the risk assessments and provide supervision based on the need that is discovered. The pretrial services organizations, and I'm sure you're aware of what your agencies in the state, how they are working. But typically what the pretrial services program does is collect and analyze defendant information to assist the court and to take that information to inform the court in the decision that will be made by the judge. So they will, after doing the risk assessment, they will make a recommendation. And then, of course, for those higher risk cases, they can do monitoring and supervising in order to manage the risk if it is deemed appropriate that the person does not need to be detained, but can be managed in the community until trial. This morning, one of the speakers was talking about public perceptions in the state of Oregon. She was talking about people's attitudes about reform of the criminal justice system. And we also have some reports from polls that have been done looking at how people feel about risk assessment in looking at pretrial assessment and risk. In some jurisdictions, as high as 91% were in favor of using risk assessments. This is a study that was done by Florida Tax Watch Center for Smart Justice, and the poll was done in January of 2012. But nearly 3/4 of the voters, and in some jurisdictions up to 90%, were in fact surprised that there was not a risk assessment process involved in many cases. They were in support of utilizing risk assessment. And when they looked at the responses, they transcended political, racial, and ethnic divisions as far as the attitudes that were discovered. So there's been actually in a number of studies a lot of support from communities for moving in the direction and looking at risk assessment. As we look at reform efforts in the states, what states are basically attempting to do is to focus on public safety. That is the critical issue, the most important thing. Then also the critical piece, of course, is making sure that the person comes back, appears in court, and looking at our overcrowding in the jails, and making sure that jail use is minimal and less costly. A number of states are moving forward, and I'm sure you've read about some of them. There's been a lot of publicity in New Jersey. Recently, in 2014, on their second attempt, they did a constitutional amendment. They had to look at the entire system and did a statewide move. I've spoken to people in the Attorney General's office in New Jersey, prosecutors, who said our system was not working. We had to do something. And so there's a lot of people are watching this because it's an entire state that is moving in the direction. They had to develop in every jurisdiction pretrial services programs to assist with this, but put a lot of effort, had all systems players around the table. And so a lot of people are watching very closely to watch a state that is moving the entire state in this direction, because many times it's community by community that decides to tackle this issue. It's a bipartisan move. The governor of New Jersey, Chris Christie, saw a quote from him, and he said, "I want all of you to note that the ACLU and I are on the same side of something in this case." And so that has been one of the remarkable things about pretrial justice reform, is in this day of divisiveness, that this has pretty much been a bipartisan effort. Other states, Kentucky, and I understand that one of your communities had a presenter come in from Kentucky. They were one of the early states. They have a unified court system in the state of Kentucky, and they moved to a pretrial justice reform effort. Colorado, which happens to be where I live, it's not statewide. There are various communities that have come together to tackle the issue, and there is a specific Colorado tool that has been validated and revalidated in the communities that are using it in Colorado. New Mexico, I think the movement came out of the chief judge's office in the state, and it said we need to move in this direction. Connecticut, Arizona, and we already talked about New Jersey, but many, many states. The governor in New York recently has recommended a move in this direction. I saw that article in January. Many, many states are moving in this direction. So how do you move in the direction of reforming pretrial justice? Not new issue, of course, to those of you who collaborate and are part of work groups and come together to change systems. But the first very critical point is to get a really comprehensive understanding, of course, of how pretrial works in your state. You have to look at your constitution, the applicable statutes, court rules, case law, protocols, bond schedules, whether or not you're right to bail state, really understand exactly how it's working in the state and in the various communities of the state. You need to do a lot of research in your communities and understand kind of jail by jail what is happening. You need to look at things like numbers of admissions, daily jail population, your average length of stay, average bond amounts. A lot of states find it helpful to do one-day snapshots where you have you look at the numbers, how many are on pretrial status. Nationwide, what we know is that 3 in 5 statistic that I quoted earlier, or 60%. I was just in the state of California, and they had done some research and found out that 60% of the jail populations throughout their state are pretrial. So you collect the comprehensive data and take a look at exactly what is happening and get a sense of who your jail population is, so that you can begin to address the situation of having perhaps in your view low risk people who would not have to be detained prior to trial. Statewide conversations, just like you have done around justice reinvestment, are really critical, so that you can talk to each other about concerns that you have about the system. Sharing information, sometimes it's really hard to get the data that you need. Perhaps all your jails in the state don't track some of the information, and so taking a look at, is that possible? How can you do that? Can communities receive some kind of assistance to set up a tracking program and to do more study about their population? And like we talked about before, defining the terminology to make sure everybody's on the same page. Obviously, pretrial justice means that justice reform is that you're going to look at public safety most critically. And you have to understand, which I'm sure many of you already do, looking back on your experience with justice reinvestment. But any change that you make in the system is a cultural change, and it can be very difficult and it's hard. But you start with saying, what is our value here? Who is it that we feel like needs to be detained? Who do we want to focus on as far as detaining people in our jails? And is there a possible way? What is our value for managing people outside of detention? We understand that passing new laws and affecting change is just the beginning, because as you move forward, then people have to be trained, just like we said in the state of New Jersey, where they had to develop pretrial service agencies. It takes a commitment. It takes an initial investment to make these kinds of changes. And of course, it's really critical from the beginning to build in evaluation. You've established your vision of where you want to go and how you want to get there. And then you have to stop periodically and say, okay, where are we? Are we moving toward where we want to go on this issue? Do we need to step back? Do we need to make some changes? And continuing to evaluate to make sure that you are moving towards your goals. My colleague, Lauren, is going to pick up here, and we will take any questions that you have at the end of our presentation.
Thanks, Carol. Good morning, everyone. It's such a pleasure to be in Oregon speaking with you all today. As Ann mentioned earlier, my name is Lauren Dedon. I'm a policy analyst in the Homeland Security and Public Safety Division at the National Governors Association based in Washington, D.C. Our organization, just to provide a little background of NGA, we're divided into two sides. One side deals with federal relations and deals directly with Congress and the administration on behalf of the governors. And where I sit in the Center for Best Practices, we work directly with governors' offices and their staffs. We're the bipartisan voice of governors in our nation, and we focus on a variety of policy areas. And I focus primarily on public safety and criminal justice issues. And I'm here to talk today about the National Criminal Justice Reform Project, which is a partnership with the National Criminal Justice Association Center for Justice Planning, where Carol sits. And we are providing long-term technical assistance to reform criminal justice systems. Our goal is to assist 5 states in advancing system-wide criminal justice reform through the development of sustainable, comprehensive strategic planning processes in states and the adoption of criminal justice programs that are data-driven and evidence-based. And as you may have guessed, Oregon is one of the 5 states that has been selected for this long-term technical assistance opportunity. So taking a step back and kind of looking at the national view of criminal justice reform that we've seen nationwide, we really have seen a bipartisan consensus on the need for reform due to mass incarceration and the fiscal implications that this has had on states, statewide, and associated community implications as well. A number of governors mentioned criminal justice reform in their State of the State addresses last month, whether it was and related to institutional reform or improving the reentry process, reducing recidivism rates, the implications of mental health and the intersections that we see there with criminal justice involved populations. This is definitely on the governor's minds. And we know that numerous states are engaged in reform efforts to this day. And while initially promising, many reforms have not resulted in sustained change. This has been due to shifting politics and leadership turnover in state legislatures, gubernatorial transitions, and executive branch turnover as well. We've also noticed that oftentimes executive branches lack capacity to incorporate data and evidence into decision making. We've also seen an inability to maintain and sustain momentum in states. I come from a state where we've passed a vast criminal justice reform policy, and after the years of doing that, we're experiencing a little bit of reform fatigue. So really keeping that momentum going is important. We also see that a lack of sufficient buy-in at the programmatic level, whether it's in state agencies or at the local level. It's important to focus on that as well. So our sort of theory of change really relies on the mandate for change that a governor can provide in their state and the ability of the governor's office to convene these critical stakeholders. In partnership with the governor's office, we really believe that long-term reform requires bolstering of the state administering agency's capacity, the agency that deals with burn JAG funding and other data and evaluation within states. So this partnership between the governor's office and the SAA is really crucial in kind of how we see reform being sustainable in states. So our kind of 5 bucket areas for NCJRP are reforming pretrial systems and bail, improving the reentry process and reducing recidivism, addressing mental health and substance use disorders and criminal justice-involved populations, safely reducing prison and or jail populations, and addressing evidence-based practices, access to data, and information sharing practices. These are intentionally left broad because we know that they all intersect and overlap with each other. And to give a little background too, last October we held a 20-state convening summit in Denver where we had 20 states come and bring teams of the SAA director of their states and the governor's criminal justice policy advisor, an advisor that each governor appoints in their state that kind of tracks it can be a cabinet level member of their staff or someone from their policy office in the governor's office. So the SAA and the CJPA led teams of members of the judicial branch, programmatic staff, people from the legislature. These teams came and focused on one or two of these priority areas. In a meeting similar to this, we didn't have 1,000 people, but it felt like it sometimes. But we really, states really focused on these areas, with also a focus on implementing evidence-based practices, including improving that access for data, strengthening information sharing practices, adopting performance metrics, and integrating evaluation, as Carol discussed earlier. So the state's criminal justice policy advisor and criminal justice administering agency will lead teams of policymakers and key stakeholders to embed a strategic planning process for advancing and sustaining reforms within each state's executive branch. We believe that this process will enable executive branch agencies to address priorities, enhance decision-making, and achieve system-wide improvements in areas where governors can really drive change. Our sort of process that we've outlined within our states that we're working in is really empowering an executive policy advisory committee to manage the strategic planning and reform process. As I mentioned earlier, a lot of states, as we know, have been through a JRI or other criminal justice reform process and already have these task forces established in their states. So we really want to leverage and work off those and any associated work groups or subcommittees that come along with that. As stated before, we really want to emphasize this ongoing strategic planning process to focus on one of those 5 priority areas of change and develop recommendations and an evaluation plan for reform. After this comprehensive strategic planning process that the state undergoes, it'll be then time to identify, implement, and evaluate these evidence-based programs, policies, and practices. And then as these are being implemented, ongoing assessment and assessing the effectiveness of the strategic planning process and these reforms. So we have already been through round one selection of our project selection. Of course, Oregon is one of the states, as well as Arizona and Illinois. We're currently in round two selection. We have 2 spots open, of course, and we really wanted to intentionally keep those spots open for new governors. This last election cycle, we had around 9 new governors elected, some other gubernatorial office transitions occurring, so we really wanted to leave an opportunity open for new governors to apply for this technical assistance. So we really want to focus on bolstering this network of states. We want to really build a class of states where we can learn from each other. We want Oregon to be sharing what they're doing and what's working in their state with Arizona. And if something's not working well in Illinois, we want our other states to kind of build that network as well. And just to provide a general overview of kind of what some of the other states are focusing on, Arizona's focus is on improving the reentry process and reducing recidivism, as well as strengthening approaches to address substance abuse and mental health disorders, particularly with opioid use disorders. Illinois' governor has stated publicly that 25% reduction in their prison and jail populations. Their focus is on safely reducing those jail and prison numbers. And of course, Oregon is focusing on pretrial reform and with an emphasis on the intersection of mental health. So as we heard earlier from Governor Brown in her statement, there really is a commitment from the executive branch to take a look at not only the whole criminal justice system, but really pretrial reform particularly. We've already been working with the governor's criminal justice policy advisor and governor's office, the state SAA director, and criminal justice commission staff in this effort. And we know that, as in any state, there are challenges that exist that we will be taking a deep look at throughout the rest of the year in this technical assistance opportunity. We'll be looking at a validated risk assessment tool. We know some counties are using them, and we'll look into see how this can be expanded or modeled in additional counties. The issue and challenge of data, making sure that we're collecting the right kinds of data, and not that we're only collecting it, but that it's being analyzed, and that there's a way to have it be accessible from other state agencies on the local and state level. We also know that there's jail and hospital crowding within the state and lack of sufficient alternatives to incarceration, leading to forced releases. So these are all some of the challenges that are not unique to Oregon, but we'll definitely be taking a look at in our project. The public safety task force that exists in Oregon right now will sort of be the oversight body that we'll use and leverage with the pretrial work group as our focus area working group with subcommittees depending on issue area underneath that. So we'll convene multiple subcommittees to perform a comprehensive review of Oregon's pretrial practices, as well as national studies and best practices, and report back to that public safety task force on their findings. The task force will then make recommendations to the governor, chief justice, and legislature upon these findings. So all to say, our work here is just getting started. We're so thrilled to be here in Oregon and working with the great people that really care about the state and people within it. So it was clear from Oregon's applications to this project and the work at our 20-state convening that you all are really committed to this effort. And our organizations are really here to listen and learn from the people in the state. You know Oregon best, and we're here really just to support and provide coordination for achieving Oregon's goals. So, I want to say too that we have some handouts about reforming pretrial and release up here if you want to take them as you leave. But with that, thank you again for the opportunity to be here with you today, and I think we have quite a bit of time for questions too.
Just raise your hand if you have a question so I can bring the microphone to you. I saw you first, sir.
Thank you for an interesting presentation. I'm sure both of you are aware that Oregon has a rather unique bail system because we recog a lot of people and don't have bail bondsmen. Is it your opinion that we should just get rid of bail entirely? Or is the way we do it now with bail available but most releases straight recog, is that a reasonable compromise? I don't know how much money the state of Oregon makes in being the bail bondsman, but I suspect we might be hesitant to give up the cash.
All of you heard the question about your unique system. We come in to assist the state in doing its own analysis. If you talk to my colleagues at the Pretrial Justice Institute, in fact, I mentioned I was in California, and my colleague Mike Jones was sitting beside me, and they are proponents of no cash bail, totally gone. And I think, that's certainly one perspective. At the NCJA, where I am, our membership approves all of our policy statements. And our opinion is, that we certainly need to get away from the over-dependence on the financial part of this, because the real issues are risk. So we really don't come in with an agenda to tell your state what direction they should go, except to closely examine the system and move it according to your vision. But I think that would be part of the research that would need to be done. We talked about how you really have to understand how bail is working in your state, and I think that would be an important part about what is happening with the collection of those monies and how it's affecting the state. So that's a wishy-washy answer, perhaps, but it really is our focus that you are the experts on your own state.
Thank you. One category you missed were elected officials. And so you have to excuse my ignorance because,
I'm sorry.
because I am not in the system. But I have two questions. One, I have the 3-day court campaign. I thought that was really interesting. What is the reasoning behind why those full 3 days makes a difference in an increase in people reoccurrence of crimes or occurrence of crimes? And then my second question has to do with the mental health intersection, because you didn't really talk about that aspect. How does that fit in with the study that's going to be happening?
Okay. I'll respond about the 3 days count effort. And I think, like I said, it was a quote originally that came out of a Missouri situation. I think frequently, and you prosecutors and defense people could probably inform me, but I think 3 days is a rather common amount of time throughout the country that people are detained before there's a first appearance. It depends on how the state handles first appearance, and if it's over a weekend, if an arrest occurs Friday, and is there going to be an opportunity to go before a judge before Monday? But that is where it came from, and then the Arnold Foundation did the research and zeroed in on that 3 days, and it's a real pivotal amount of time. Then I quoted also what happens if it's longer and the impact that seems to have on outcomes. But that's basically where the 3 days count came from, right? And your other question, intersection of mental health. And I don't know if Lauren may have something else to add. I know that this is a concern. We've had discussions at the Criminal Justice Commission and the taking a look at the number of people that are in jails. This is actually, with a mental health issue. This is a national problem. Because of the reduced funding for mental health services throughout the entire country. That's had a devastating effect. And now law enforcement and corrections are finding themselves in the situation of trying to deal with the mental health issues in our country, the severe ones. So this, once again, it will be part of the research that needs to be conducted as you look at your jails and actually get some good hard numbers on how many people are in your system pre-trial, how many have mental health issues. I have heard jail administrators talk about an unbelievable numbers of the people within the jails who are suffering from mental illness. 50%, 60%. I hear those kinds of, but I do not have a number for Oregon, but it's certainly something. That's how we would look and see how that factors into your entire treatment of pretrial justice in your state.
I know we hear a lot from different either directors of departments of corrections or whatnot, or local county officials that operate jails and sheriffs, that jails are becoming de facto mental health institutions. So in our conversations with Oregon thus far, we've identified different data points that we need to be tracking, and including the percentage of jail inmates diagnosed with mental illness and length of time for mental health assessment within jails, and if assessments are even happening too. So that's definitely part of our research and evaluation component of our work here in Oregon that we'll be beginning. And another asset that we really want to bring to the table too is just different national subject matter expertise. So at NGA we have different mental health experts on staff that deal with superutilizers of the system and whatnot. So we'll be leveraging those, as well as if there's another component of expert that we can bring in and really assess and evaluate what's going on in Oregon. That's something that we'll want to bring to the table as well.
I'm a public defender, and I have two questions. The first relates to, and sorry, my name is Brooke. I'm from Lane County, and my first question relates to: have you guys studied the impact of getting the defense bar in on the initial release decision as a critical stage hearing, and whether that improves outcomes? And my second question is: have you studied, or is there any research on whether there's a way to release people who've already served the maximum presumptive time they're going to, even if they were to plead out to the charge? In other words, to prevent people from simply taking deals to get out of jail as opposed to waiting for a trial that might be another month down the line.
I will tell you that everybody heard the question. Do I need to repeat? Okay. Regarding the defense being at first appearance, I think that this is a very critical part of pretrial justice reform in most communities for exactly the issues that you mentioned. I am not on the spot aware of recent research that has been done in states about the difference that it has made when defense is there, but I do think that that is a very critical part of pretrial justice reform, because I think you're absolutely right. There are numerous anecdotes. We just spoke about women involved in the criminal justice system, and you hear the stories about the women who have been arrested, they're being detained, and they just want to get home to their children, and so we'll take some kind of a deal that before actually weighing. And then, maybe get bail and lose bail. And so I'm afraid I don't have research, but all critical points that you would want to look at in the state. And be glad to see if I can find research, but I'm not aware of any at the moment. Excellent. Thank you.
Hi, I'm a judge, and I can tell you that some of the counties have received varying degrees of pressure to reform, from a county standpoint, some of the processes that we go through. Given that now that a statewide endeavor is being embarked upon, is it more desirable to kind of wait till we get this workforce in place where we can see the recommendations and take kind of a uniform approach? Or do you want to see counties by county sort of piecemealing this and making individual reforms? I would be very interested to know kind of both sides of that.
Speaking to one of our other states as part of this project, Illinois, they have a very county focus. What they want to do is really focus on their varying counties and have that kind of statewide oversight going on. I think what we wanted, we're flexible to the state, and we're not going to, our research project isn't going to come in and tell you exactly what to do. As we said earlier, we're learning about from the experts here and through our future work group meetings as well. So I think as the work group bolsters up and gets subcommittees identified with to the gentleman's question earlier too, including all the important stakeholders such as defense, I think that's a question and a move for the state to determine whether to kind of have a more comprehensive approach and outlook on how these reforms need to be done, but with the knowledge, of course, that counties and stuff is happening all the time. There's not going to be a time where, nothing's going to happen for 6 months while we're doing the strategic planning process. States need to move, states need to implement. So I think just making sure that we're including county representatives in these conversations is crucial as we move forward.
Hi, a couple questions. Who was at the table to define what success is for Oregon? And what is success? What kind of data are you looking at? A statement too. I know we're all scared that funding is getting smaller and smaller, but I think this is a great opportunity for us in Oregon to be really creative, and we can get new people at the table, new ideas, and I think we can do it here. Even better, we can be in competition, right, with Illinois and Arizona. And we can do it. And I had a question, too, about linguistic analysis. So is there any work being done in criminal justice? For example, in linguistics, we do discourse analysis, meaning we study what words are used when people are talking, how the conversation is going, how the questions are going. And I'm thinking for mental illness, some kind of study like this would be helpful. So who determines success? What is success in linguistic analysis?
I just want to make sure when you say success, as in the success of this project in Oregon. Okay, so one of the first parts about our work in these states, in Illinois and Arizona, have already had more of a kickoff meeting with the executive task force. So it would be the public safety task force here in Oregon, the pretrial work group, and then various subcommittees. That meeting is scheduled to happen next month in March. So that will really be where we do the mission and vision setting. We want the outcomes to be a part of this process, more detail about how the strategic planning process will work, how we're going to be integrating evaluation ongoing. So a lot of that level setting will occur at that meeting next month. So, and I think as the I think there's a pretrial work group meeting tomorrow afternoon, actually. We'll be kind of talking about that a little bit too with the work group. But really, as they start developing who they want on their subcommittees and inviting and convening stakeholders as well, hopefully everyone in the room will be part of that as well.
I think that's a very interesting perspective. I talked a little bit earlier about defining terminology to make sure you're on the same page. This is a little different from that, but I think is important. I will say we have an ongoing evaluation process, and I think the use of words, in evaluating how the project is going is, it's critical. But I don't really have. We haven't addressed that in just those words.
Because of the Arnold support for this effort, does that mean that Oregon would have more direct access to the public safety assessment should they choose to go that route?
So the Laura and John Arnold Foundation is our funder for this project, and they have been interested in pretrial for a number of years. They are in the process of not only looking at their universal tool for risk assessment, but also other evidence-based programs as well. And so after the states undergo the strategic planning process this year, knowing that other stuff will be going on at the same time, Laura and John Arnold are also providing a list of programs that have been evidence-based and whatnot that we'll be taking a look at, too, for implementation. So that's definitely a component of this project, is using kind of what they've developed and what they've validated as well.
I just had a comment that's in the form of a question, because as a prosecutor, I see from a rural suburban county that is next door to a larger county, separated only by a river. We have a jail that is much larger than the county next door, yet they have community resources that are larger than ours. So it's kind of a contradiction that creates some interesting results, yet we share a police force in one of my cities. So that creates some different issues for us. So I hope, as I see national organizations working with our executive branch, that you don't do a broad brush type of approach, that you really take time to consult with individual counties that have individual issues, because that creates individual challenges in terms of jail space and individual community resources. We're all trying to get to the same place and dealing with these issues, but we have different constraints. So I really hope that as you're going forward with this project, because some of the issues that we're dealing with in terms of the mental health issues and trying to defer people mental health who face mental health issues, are the conversations going on in the room at this very same time with some of the people from our county leading that discussion. And I'll tell you, we're doing some exciting things in my county with limited resources. And to my friend from the defense bar who raised another issue, we have defense lawyers in that committee raising, due process issues on behalf of their clients. So it's a good conversation, but it's very community-based. So I do hope when you come into our state, you go deep down into the counties, because we're very different, but we're very similar in a lot of ways. So I'm fascinated by these issues. So thank you.
Thanks for that comment. That's really exactly the kind of feedback we're hoping to take back as we discuss with our colleagues as well. My former career was in the governor's office in Nebraska, so I'm very sensitive to the rural-urban. Nebraska's really got two cities, Omaha and Lincoln, and the rest is all rural cities and towns. So I'm very interested in that particular subject and sensitive to that. So thank you.
I'm actually from Utah, and we've had a pretrial division there for probably 30 years, but only in one county, in Salt Lake County. And one of the problems that we see is we will have people come in, and our pretrial is really good. We have screeners in the jail, and they do now, in the past year or so, started doing risk assessment using the LSI, CM, I think. And so they're doing a lot of evidence-based and different practices like that. But one of the biggest problems, we're talking about mental health and substance abuse, people can be released, but there are no resources. You've got agencies that do a great job, but they only have 50 beds and they're full, and you have a waiting list of 150 people. And on the defense side, they want to get their people in these treatment agencies so that they can have a better result in the court. So again, with funding, that's a big issue. You get people out, but you can't do anything for them. And the people who do have money can get out and they can fund their own bed or their, it's substance abuse or mental health. And so it does make a huge difference in the outcome of, and so how do we get funding to help the people who don't have the money so they're on an equal level?
I think one of the goals we have for our work here in the states that we're working in is really leveraging different federal funding opportunities as well, particularly with substance use disorders. There's been a lot of federal money through 21st Century Cures Act and other SAMHSA funding as well that really focuses on not only, and BGA has an opportunity from the CARA bill that was passed for opioid use disorder, criminal justice involved populations, and really linking up that post-release community care treatment focus. So I think that's something that every state struggles with, and we're definitely, it's hard with our bucket areas too because everything intersects with each other. So, one state could not vocally say they're focusing on mental health or substance use disorders, and it's there no matter what. So I think as we continue to learn and figure out our plan for the state, that's definitely be a focus of our lens.
This for you, Lauren. I was really interested when you said with the initiatives you've seen a lot of failures, right? So we all know that there's a lot of efforts to make change and they're not sustainable. So could you say more about what are you learning from the failures?
Sure, and I want to be careful not to call them failures, but I mean, I come from a state too that I helped usher through the criminal justice reform project in Nebraska, which is a 3-branch effort, and a lot goes into the legislation that's written and the implementation portion as well. And I think all of us know that, you know, everything can look great on paper, you know your numbers, you know who you're dealing with, but then in the implementation phase, there's a million other things happening. Numbers aren't, projections aren't actually what they seem to be because there's so many other, whether it's pieces of legislation that you didn't think would have an impact on criminal justice reform. I think there's a session tomorrow on hidden collateral consequences too. There's just so many layers when you're doing some sort of criminal justice reform that I think our focus really is in embedding the strategic planning process with this focused areas of reform and really embedding that in the system so that if a staff member from the SAA leaves, this really becomes a culture of the strategic planning involving the governor's office, involving these work groups that maybe will sunset in certain statutes, but that those relationships will remain there with the focus of going through any gubernatorial transitions or staff turnover that leads. So I think really embedding that process is our goal, and we hope will really be successful in sustaining these results.
Well, we've got about 10 more minutes before the end of the official session. If anyone has more questions, still plenty of time.
There's a new process. Instead of doing strategic planning, it's called strategic doing. Have you heard about that? It's taking hold at the University of Oregon, so if you're interested, I can hook you up. It combines the implementation with the planning.
Yeah, thank you. Good to know.
All right. Thank you so much, everyone, for coming. Thank you so much for that wonderful talk and excellent answers to the questions, and we'll see you around.